Welcome to Ask a Debt Collector, another case study with regards to an Fdcpa violation where you have a person trying to sue a debt collection company. I want to continue to bring you guys these types of cases. Number one, because all over social media, a lot of times you'll see, oh, this violation, you can sue for these reasons, and it's very simple and they make it seem very easy. Me being in the debt collection industry for over 15 years, I've seen where consumers have tried to sue debt collection companies. I want to bring you these cases so that way you can see what to do and what not to do if you are trying to sue a debt collection company due to violation of the Fdcpa. So if that's something you're interested in, stay tuned. Hey, I wanted to jump in right now and tell you guys not to forget down below to check out my free letter bundle. You'll get 4 letters absolutely free to help you on your credit journey. There's a pay to delete, a goodwill letter, a cease and desist letter, as well as a debt validation letter. That's to help you out on your journey. Be sure to check that out in the description down below. So it's very, very important to understand that this person was trying to get violation of the phone calls, which is the TCPA, as well as a violation through the Fdcpa. All right, there are 2 things that was going on. So let's get into the case itself. In the Woodman versus MediCredit Incorporated, the case arose from 3 separate medical debts assigned to the defendant for collections. Now that's very key, 3 separate medical debts. The plaintiff retained a legal representation in April 2021 for her first 2 debt accounts and notified the defendant of this representation. You have an account, let's say, we'll just say the medical field. For those of you who are in America, if you go and you have insurance or no insurance, if you go to the hospital, you can get a lot of bills that can actually happen. In the case of Woodman, she had 3 total debts, but at the time, she only had 2. And let me explain what could happen. If you take an ambulance to the emergency room, and let's say you have a copay, or you don't have insurance, that's a bill. Then you get inside the hospital to see a physician with regards to him checking you out or whatnot. That's going to be a bill. Let's say that you had to get an x-ray or something along those lines. You had a broken arm, they had to x-ray it. That can be a separate bill. So what happens a lot of times with medical bills and collection bills in general, if you have multiple ones with the same company, sometimes they'll send the bills out in series, right? And it's just all dependent upon when they get the actual bill and how long it took before it was actually paid and them trying to collect on it. So a lot of times, because it's a medical bill, we as consumers may think, oh, okay, they're calling me about a bill. It's the same medical bill, but sometimes it's not. It can be 3 separate medical bills. And that's the case with regards to this. But let's go on with regards to reading on the case. However, the 3rd account was placed with the defendant in June 2021, and there was a dispute over when the defendant received the notice of representation for this 3rd account, with the plaintiff claiming notice in June and the defendant claiming notice in August. The plaintiff alleged that she was contacted on 6 occasions despite the defendant knowing she was represented by counsel, constituting harassment and unfair practices under the Fdcpa. Additionally, she claimed that the defendant used the automatic telephone dialing system, ATDS, to contact her without her consent in violation of the TCPA. And the defendant contended that any communication with the plaintiff between June and August solely related to the 3rd debt account when the defendant did not have a notice of representation. So to break this down so that you guys understand, basically, Woodman from MediCredit Incorporated received 2 letters with regards to medical debt that she actually had. She had legal representation with regards to the medical debt that she sent to the debt collection company, letting them know like, hey, I'm being represented by an attorney. That was back in April. 2 months later, the debt collection company was assigned another medical bill that was different. So it's a third medical bill. When she let them know about the two accounts, it was a third account that was placed in their office about 2 months later. And because that third account was placed in their office, I'm guessing the debt collection company contacted her with regards to paying it. Now, I'll be honest with you. When accounts, because I worked in debt collections, there are accounts where they'll come into our office and it'll be two accounts. In this case, let's say two medical debt accounts. Because the first and last name and the social security number is the same, typically the software will combine both of those accounts. When you call the consumer who actually owes the debt, you will see right in front of you, oh, they have two accounts. So as you're talking and negotiating, you're saying that. In this case, she had legal representation, so the company could no longer contact her. 2 months later, another account came in the system. Now, the reality is, I'm not sure, and I can't speak for this debt collection company, if they had a software that connected the accounts. Most debt collection companies, I work for one that was probably smaller than this one. And so if that third account would have came in, it would have attached to the same account. Let's say that you had to manually go in and attach it. If that's the case, when those accounts come into the debt collection company's office with another series of accounts that are actually being collected on, it may not be attached to that. So there's a possibility it could have gone on to another debt collector on their floor. It was assigned to another person. They're just doing their due diligence like normal. They have to mail a demand letter to this consumer, and this consumer probably saw was from a debt collection company, the same one as the two before, and probably just dismissed it and threw it out, right? And so then when she began getting calls, she was like, wait a minute, you're calling me again for a medical debt that I have already told you guys I have legal representation for. And I'm pretty sure she hung up, probably didn't explain or talk. Now, I've had cases in the past when I worked in debt collections where this would possibly have happened. And if I got that consumer on the phone and they were like, well, I just got a call a month ago about two debt collection accounts that I already have in you guys' office, and I told you I had legal representation, right? Then at that point in time, I could have looked as a collector, looked in the system, seen the actual account and said, oh, this one is a separate account. It's not included in your lawsuit. So you as a consumer, if she would have paid attention to the letters that she got, and I know it's very hard to do so because you just hear one debt collection company and a medical debt, and you assume that it's the same thing across the board. But her having two accounts, what's the chances of her having a third account or fourth account? Very high, but a lot of consumers, they don't know that because in their mind, when you go visit a hospital and there's a bill that comes out that you owe, you think that everything's included. But unfortunately, sometimes, like I explained to you guys before, you may get bills from different departments within the conglomerate of that hospital, right? As we know, they handle all different things. Not only is she upset about being called and having legal representation for debt, but she was upset with regards to the TCPA. And those are those automatic calls, right? I don't know if you guys have ever had them. I've worked at a company where they basically take all the accounts on the collection floor and put it through a dialer system, right? And that dialer system will make calls way faster than we can manually. And so they'll make a bunch of calls. And then there are about 20 collectors on the floor. And anytime someone will pick up, automatically the account will be transferred randomly to a collector's desk who has a free phone. And once we pick up the line, right on our computer, we'll pop up the account and we can make the call. They're stating that that happened. Now, there was a law that was passed where you can no longer use this dialer to make the calls, which made it easier for collectors, but it would be very aggravating for a consumer. And so they're saying that they had a call through the dialer system as well. So not only was she saying there was a Fdcpa violation with regards to contacting her, with regards to a medical debt that she had legal representation for that she told that company for, but the TCPA with regards to the dollar, they're saying that violation. So basically what happens is because she had legal representation for those two accounts, told that collection agency, in fact, that was the case, when the third account came in 2 months later, and it was placed on the floor and they started making calls because it was a brand new account. Based on the reasoning, the court found that the plaintiff had provided her phone number on her medical admissions form, which constitute express consent to receive calls related to the transaction. and the hospital had provided those numbers to the defendant for the debt collections. Therefore, the defendant's actions were compliant with the FCC's interpretation of the TCPA. A summary judgment was granted in favor of the defendant on this claim as well. It's very important to understand when you're filing a lawsuit with regards to an account, number one, you got to understand what type of debt it is. If it's a medical debt, the laws are a lot different. There's HIPAA laws that debt collectors have to follow with regards to calling and collecting on those debts. I hope this is some information to help you on your credit journey. If you are trying to file suit with regards to violations of the Fdcpa, or in this case, with regards to the TCPA and that dollar system contacting you, make sure before actually trying to file suit that you understand the laws by hiring an attorney, number one, or number two, that you're very course if you're going to represent yourself and understand that there are always going to be technicalities concerning that. If you have any questions, put it down in the comment section. I promise I'll answer those questions, and as I always state, you be great.